topic, as you can see, is collateral warranties and other protection for the employer under NEC. So what we're going to be looking at are all those sort of additional bits of security that employers, developers, and sometimes contractors in a subcontract want from the party carrying out the work, and the risks around them, what they mean, and the penalties, what happens if you're required to provide something and you don't. So just to put it in context, this is the third webinar for this season. So the first one was a kind of high level look at NEC, how it works, tricky bits, etc. Last month we looked at NEC 4 just to try and get to grips with this. So we're sort of looking at those high level items, and of course this is a slightly different topic but similar vein. Coming into January, February, March, we'll be looking in more detail at the NEC provisions, and in particular January we're going to be looking at typical examples of Z clauses. So one to watch out for. So if we can just have the next slide, please, Jan, which sets out, and the next one, please. So sets out today's agenda. So as we've seen, collateral warranties and the rest, with one exception, are all areas where contractor or subcontractor is giving the paying party additional security. So retention, hopefully you all understand what retention is, but it's about the paying party retaining sums of money due. It's I don't know, I think it's probably unique to construction, where you've done the work, the amount of money is due, but 5%, 6% or 3% is deducted, and half of that typically deducted for a year or so after the work's been completed. So that's the first one we're going to look at. We're also going to look at parent company guarantees and how they fit into NEC. Linked to that are performance bonds, and also I'm going to talk a little bit about how they've evolved over the years, not so much in terms of what the documents say, but the requirement for these documents, because as with most things in life, the legal position and the commercial position changes, it sort of fluctuates over the years. So we're going to look at those. Then of course there are delay damages. You will be familiar with that, but again, particularly if it's liquidated damages, which is most common for a contractor, it's another way for an employer to withhold money that would otherwise be due. Also going to look at contractors' liability for design, just to put in context, how long a contractor will be liable for their works. And I mean, that length of time includes workmanship also, not just design. We're going to look at limitation of liability in clause X18. Now, that is the one item that will benefit the contractor or the subcontractor because it's limiting your liability. But you'll see, particularly with things like collateral warranties, how it's relevant to that. And then finally, we're going to look at clause 50.3, which, spoiler alert, is sums that the paying party can deduct if the contractor doesn't submit its initial programme for acceptance within timescales. So, yep, I'm afraid it's yet another deduction that can be made against contractors or subcontractors as appropriate. So if we can have the next slide, please, Jan. So there's quite a few slides on collateral warranties, and they kind of always seem a little bit mystical, I think, to lots of people. And I think part of the problem is the name of them. What is that all about? I think if you just think of it as, it is just a contract between primarily two parties, but a third party does sign up to it as well, which I suppose adds to the confusion. And, why do we have collateral warranties? Well, we have them because of a fundamental point in law, contract law generally, so not just construction contracts, which is that if you have a contract between employer and contractor, they are the two parties to the contract. They have obligations under that contract, and they're owed obligations by the other party. But it's between the two parties, it's private, as it were. And it means that third parties can't use that contract or make claims against either of the parties on the basis of that contract. And of course, in construction, we often have long supply chains. So the collateral warranty is a means of giving effectively a contract to third parties so that they can pursue really the construction parties, the main contractor, the subcontractors, and the consultants, if there is a problem with the work. So generally, we're talking about defects in the works because we're thinking about a situation where the works were completed 3 years ago, a defect is found, but subsequent to completion, the original developer sold the premises to a third party. And hopefully you can see it wouldn't be particularly fair if third parties bought these premises. Could be an office block, it could be a block of flats, bought the premises, and because of privity of contract, they can't pursue the party who hasn't built the property properly, as I say, because of privity of contract. So what we have is the collateral warranty creates a contract between whichever one, contractor, subcontractor or consultant, and future purchasers, funders, etc. So if we can move on to the next slide. If that's not clear, it will become clearer. So how is it dealt with in NEC and JCT? So the first bullet point, we do have third-party rights provisions in NEC, but also they're contained in JCT as well. That's the 5th bullet point down. So third-party rights is basically an act of parliament that was introduced. Can't remember the year, but it was quite a long time ago. The idea was that the parties in the contract that they sign up to state which are the third parties to benefit. And the idea is that you then don't have to have these extra contracts, these collateral warranties. Now, in my experience, they're not, the Third Party Rights Act isn't well used. Typically, I am told the funders, so the banks, etc., don't really like it very much. They like to have their collateral warranties. So we're still, in a position where we're providing collateral warranties. So the third bullet point down shows us that NEC 4, and we talked about this last month, has a new option X8, which is called undertakings to clients and others. And I explained that's basically collateral warranties. So that is the provision in our engineering and construction contract for collateral warranties, albeit that it doesn't call it that. Now, in my experience, that might be used, but it will be amended, or it might be deleted and a whole new requirement for collateral warranties included as a Z clause. So I think the first thing to remember, if you are reviewing an NEC 4 and you see that option X8 doesn't apply, don't assume that you don't have to provide collateral warranties. You might find that it's all set out in detail in the Z clauses. We'll kind of talk about later what the Z clauses will cover, but as I say, it's in more detail than just you're required to provide a collateral warranty. 4th bullet point down, the warranties. So the collateral warranty, it is just a contract, but with a funny name. it will be a lot shorter than your typical form of construction contract, and we'll look at in a few minutes' time the topics that they typically deal with. But usually the collateral warranty, the form of it, with blanks obviously, but the general form of it will be appended to your construction contract, so you get chance to review it before you sign up to the construction contract itself. So you do need to review it, and we'll look at some of the things you need to look at. Next bullet point down, as we've already seen, JCT has a section on collateral warranties or the TPR. So TPR, third party rights, or collateral warranty options. And I said that we would look at what happens if you are required to provide a collateral warranty and you don't. Well, under NEC, clause 91.2 applies. So if you're familiar with NEC, you'll know that the clause 90s are all to do with terminations. This isn't good news. If the contractor doesn't provide the warranty and the project manager notifies the contractor that it has defaulted, so gives it extra time. So I can't remember what the time scale is. I think it's probably 14 days. If after that notice they still don't provide the warranty, then the employer or client may terminate the contract. So just be careful about that. Next slide, please. So what form of collateral warranty might you see? Well, the first two bullet points deal with this. So we have a bespoke one. I would say that in 99% of cases, that is the one that you will see and the one that you will be signing up to. The alternative is a sort of industry standard. So I think JCT has one. I'm not sure. I don't think NEC has. The difference between the bespoke is typically, so most law firms have their own bespoke ones. Developers, will have one that they tend to use, usually that, their lawyers have prepared for them, etc. So that's bespoke. Now, whilst I say they're bespoke, we'll see later that they tend to deal with the same things. It's just sometimes it's slightly different wording. The industry standard is kinder to the contractor and the subcontractor than the bespoke ones tend to be. So just bear that in mind. But as I've said, the industry standard ones are rarely used. So the next point to think about is for contractors and subcontractors, get your insurers, particularly professional indemnity insurers, are usually happy to review these documents and give their position on it. Even if you're not interested in what their view is, then it sometimes helps with negotiations. What we find is that if an insurer is saying, "Oh, this clause is unacceptable," for our policy, that is more likely to persuade an employer, client, developer to amend the term, rather than contractor or subcontractor saying, "This, I don't like this clause; it's not acceptable." And then finally, contractors, ensure that your subcontractors and, of course, any consultants check the warranties that they will have to enter into, which will be in pretty much the same form as the contractors. Encourage them to check them with their own insurers. I think that's also helpful for the same reasons as we've just discussed, but also from a contractor's perspective, so that your subcontractors do know that they are going to have to provide collateral warranties, so that when you ask for them, there aren't difficulties because it comes as a shock, because they possibly haven't read their contract in too much detail. And the other thing to bear in mind, of course, is that for contractors, if your contract requires you to enter into collateral warranties, usually it will also require you to obtain collateral warranties from your consultants and your subcontractors. And that is an obligation on you to do that, even though, you are getting them from a third party, it is still your obligation. So it means it's why I say, get the subcontractors to check with their insurers so they know that they have to provide them, so that when you ask for them, there shouldn't be a problem. But it also means you need to make sure that if in your contract there are requirements for you to get collateral warranties from subcontractors or consultants, those provisions need to be mirrored in your contracts with your contractors and your contracts with your consultants, possibly of course with shortest time scales, so that they provide the collateral warranty to you, you can send it up the chain within your time scale and still comply with your contract. So next slide, please. So, and some basic checks. When are you required to provide a collateral warranty? Well, this is one of the provisions that will typically be included in your contract, and it's one of the areas where, if the X clauses are being amended, quite often the timescale for providing will be specified. So it might be 14 days from request or 28 days from request. I would suggest 28 days would be more reasonable. But of course, if you are to provide a subcontractor warranty within 28 days from request, that is when you need to incorporate the relevant provisions into your subcontracts. So you can then say to your subcontractor, I need, I've been asked to get a collateral warranty from you, so can you please provide it? And they've got no reason not to. Whereas if there's no requirement in their contract to provide the warranty, the contractor's in difficulty because they have to provide it, but they've got no lever in their contract with the subcontractor to get it. So we talk about a beneficiary in a collateral warranty. So the beneficiary is the party who gets the benefit of the warranty, the terms. And if you remember back to what I was saying at the start, this is mainly about finding defects later on in a project. So after completion, building has passed to new purchaser, new long-term tenant, they're suffering the loss, they're responsible for the remedial works, and they're looking around to see why there are defects and is it the fault of any of the construction professionals. So the beneficiary is any one of these third parties for whom the collateral warranty is given. So it could be a purchaser, it could be a tenant, typically that would be a long-term tenant. It could be a funder, someone, a bank funding the project, end user, or it could be the employer. So the employer would want collateral warranties. Bear in mind, it doesn't need a collateral warranty from the contractor because they've got their contract. So they've got the rights and obligations, but they would probably want collateral warranties from subcontractors and from consultants. The other thing, and again, things change over time. Probably about 10 years ago, collateral warranties were really focused on design. So where contractors, subcontractors, consultants had design responsibility, collateral warranties were a requirement. It's shifted slightly, probably since COVID, although I am sure it's nothing to do with COVID. But now what we're finding is that employers are requiring collateral warranties, whether it's just workmanship, so no design, or whether it's workmanship and design. So, there's no distinction at the moment, which means that where the contract is just for workmanship, 10 years ago, you probably wouldn't have required any warranties, collateral warranties. Now they are being required. When you are reviewing your contract, what you need to be looking at in the collateral warranty is how do the obligations in the collateral warranty compare to the contract obligations? Because what you do not want is a mismatch, and what you definitely do not want is to find that you carefully negotiate the contract itself, but then the collateral warranty has greater obligations than the main contract, because that means you've given greater obligations than you've carefully negotiated to these third parties, which it's not logical, it wouldn't make sense, but you know, the general rule about contracts, which is what a collateral warranty is that, you know, once you've agreed it, you know, it doesn't, you know, it's not a defense to say, well, it doesn't make sense or it's not very fair. So the next slide, please, Jen. Yeah, so generally in terms of collateral warranties, I think we've probably pretty much done this. The requirement to sign up to a collateral warranty will be put in the contract, or it goes in a subcontract for your subcontractors in the appointment for the consultants. It's got to be in there. And I have had particularly subcontractors who've been asked to provide collateral warranties. There's been nothing in their subcontract to require them to do so. So they've just said, no, sorry, you know, there's no requirement. On occasions, they've said, well, we'll provide it, but, you know, it's an extra fee. So, you know, contractors need to be really careful to ensure these provisions go in, and that the terms of the collateral warranty properly mirror, you know, that a step down from the terms in the contract, and that the requirements, the logistics for providing the collateral warranties are mirrored from the contract into the subcontract. So we've already seen that, you know, there will be time limits for providing. So usually, because obviously when you sign up to a contract, there are probably certain collateral warranties that will be required immediately. For example, the funder will be on board. So the funder will want their collateral warranty pretty much as soon as contracts are signed. But of course, you know, future purchaser, well, that might happen after practical completion, in which case the client, the employer, will approach the contractor and ask for collateral warranties for this new purchaser. So they can be requested, you know, pretty much at any time whilst contractor, subcontractor, consultants hold any liability. The penultimate bullet point talks about what happens if the collateral warranties aren't provided on time. So that includes, you know, not provided at all. And that's often very much up to for negotiation, but you need to be aware of what the contract says initially, because quite often it will say that the contractor doesn't get paid any sums that might be due until its collateral warranties have been provided, that they are up to date in terms of being provided. I think that's too harsh. I think, as it says there, 10% of the sums due would be, you know, a reasonable or a more reasonable sum. And of course, the requirement that once the collateral warranties are up to date, you know, that 10% that might have been withheld is then paid back. So if we can have the next slide, please, Jan. So I said we would sort of, we had a list of the types of clauses that you would see in a collateral warranty. So the bullet points represent the different clauses. Typically, it would be about 8 pages long. What I haven't added at the end is we usually have the, you know, the boilerplate clauses, so probably about 4 or 5 clauses about sort of waiver, suspension, etc., choice of law, jurisdiction clauses. So I haven't included those, but these are the key clauses that you would have. And this is probably pretty much in the order that you tend to see these provisions. So if you remember, you know, I was saying typically, you would expect to have bespoke collateral warranties, so each law firm has its own, but they tend to follow this order pretty much. There might be some variances. So the first one talks about the duty of care. So this is talking about the duty of care being imposed on the party doing the work. So the contractor, subcontractor, or consultant, if it's their collateral warranty being provided. And so this is one of the areas where it's important to make sure it doesn't differ from the contract itself. So you'd expect it to say reasonable skill and care and not fitness for purpose. Second clause would be about not using deleterious materials. Typically, you would expect to have a clause like that in the main contract. So again, they should mirror each other. Third, you'd expect to have insurance provisions, and again, they absolutely must mirror the provisions in the contract. And you might think, well, of course, if the employer, the client's lawyer, has prepared this, that they are definitely going to mirror each other. But I would say that's not necessarily the case. And very recently I've been reviewing a contract where the insurance clauses in the contract and the collateral warranty were different. So that's an issue where you would have to go back to the client and get it remedied, because this shouldn't be different. There would be step-in rights, and we'll come to that in a minute. Copyright, we all know what that means. That's all to do with the design and ownership of the design rights. Assignment is to benefit the party, the beneficiary, the party who gets the benefit of the collateral warranty, so the funder, the new purchaser, the new tenant. And it really just means that they can assign it, so they can assign the benefit of the warranty to another third party. So it's another way of passing the rights on. But again, as I've already said, it's not increasing a contractor's liability. It's just moving the liability from one party to the next, because if a building is defective, the remedial works will represent the claim and possibly some loss of use. But the remedial works can only be incurred once, so that financial claim obviously can be passed to a contractor, subcontractor, consultant, but it can only be passed once. So it's not a huge issue. And then finally, limitation of liability. So what I would expect to see, so this is another thing, as well as your reasonable skill and care, that you need to be looking out for. And this is what we call a no greater liability clause. So a clause that makes it clear that contractor, the party giving the benefit, the obligations, the party who gives the warranty as to the work, is not giving a greater liability in the collateral warranty than it gives under the construction contract. So if we can move on to the next slide. So it's just an example. It comes with a health warning because, of course, it's probably got wrong definitions in. For example, it talks about fourth line down building contracts, so that wouldn't be right for NEC. So it's just caveat alert, is just to give you an idea as to what you're looking for. So there are sort of two parts to this clause. So the first bit is the sort of first 4 lines. So the contractor shall owe no duty, obligation, or liability. So it's like including them all, belt and braces, to the beneficiary. So that's the person who benefits from this collateral warranty. So the contractor owes no greater obligation to the beneficiary or of longer duration than it would owe to the beneficiary if the beneficiary had been named as a joint client with the employer under the building contract. So it's a bit of a tortuous way of saying contractor's liability to the beneficiary can't be more than contractor contractor's liability under the contract, the construction contract itself. And then it goes on to say, end of the fourth line, and the contractor shall be entitled in any action or proceedings by the beneficiary to rely on any term in the building contract and to raise the equivalent rights in defence of liability, as it would have had as if the beneficiary, had been, a party under the building contract. So it's two phase. No greater liability is the first. The second phase, the second part is that the contractor can rely on the building contract and any defence it would have in any proceedings that the beneficiary might bring it back, against it. But that clause needs to be in the collateral warranty or something similar. As I say, it tends to be towards the end, or sometimes you will find it in that duty of care, that first section in the contract. It's unlikely to be as comprehensive as that. It might be less so, but you need to make sure that something to that effect is included. Next slide, please. Okay, so step-in rights. Right, so we've sort of written down the middle, we've got the boxes funder, employer, contractor, and then we have underneath that consultants and subcontractors. So that chain shows your standard construction chain. It could be different because you could have the employer contracting with the consultants in some contracts. But that is our privity of contract. So the privity of contract between funder and employer is that they are the parties to that contract. So they have the obligations and rights between each other. Ditto employer contractor, ditto contractor and subcontractor, and also ditto contractor and consultant. So if you remember, that's why we have a collateral warranty, because, for example, what happens if, say, the contractor goes into liquidation partway through the project, so before completion, or even after completion. So collateral warranties are needed for both scenarios. The defect scenario that we've been talking about generally relates to after completion. So you can see all the lines going up. So for example, you can see on the left-hand side, the lines going from the consultant to the employer, consultant to the funder, and CW next to it. So that's showing consultant is giving a consultant collateral warranty to the employer and the funder, so that if there are defects, the employer or the funder can go against the consultant if they want to. You can also see from the funder that they've also got collateral warranties from the subcontractor and the contractor, so can go against them for defects. Now, why might a funder or employer want to go against a consultant or subcontract? Wouldn't they just go against a contractor, particularly in a design and build? Well, absolutely they would, because the contractor is basically the one-stop shop in terms of liability. Pursue the contractor, and they then have to bring claims against the consultants and subcontractors. But what if the contractor has gone into liquidation and there are defects? The employer would then want to use the collateral warranties to go direct against the subcontractor and the consultants. And if the employer had also gone into liquidation, that's a bad scenario, then the funder would want to the right to go against the consultants and the subcontractors. And, in a scenario where it's just the employer that's gone into liquidation, the funder would also pursue the contractor. So hopefully that's clear how that works. Now, the step-in rights are more, they're relevant in a situation where an insolvency happens before practical completion. So it would apply whether employer or contractor went into liquidation, but for the sake of argument, let's assume the contractor has gone into liquidation. Employer and funder, have got a kind of part constructed building, funder's spent a lot of money and probably hasn't got something that is worth what they've paid for, possibly, if it hasn't been completed. Ditto employer. The employer's main focus is going to be to get the facility, the building, whatever, completed. And the easiest way for them to do that is to get the current team, as much as it possibly can, on board to complete the work. And this is where your step-in rights come in, because if collateral warranties have been provided, the employer has the right to require the consultants and the subcontractors to complete their works. And the employer either steps in to the contractor's role or appoints a third party, so a replacement contractor, to step in. You might think, well, that sounds really bad from a subcontractor consultant perspective, but it's actually not, because it means that they're allowed to complete the project, which is, obviously good for their business planning, their cash flow. But also what you need to look out for in these step-in provisions is that they say, and they typically will, that once the employer or whoever has stepped in to another contract, then they owe the obligations of the party that they've taken over from. It makes sense that they owe an obligation to pay the subcontractor and the consultant. And usually, this is one you need to look out for. The norm, though, is the commercial norm is that there's a clause that also states that the party who steps in also takes on an obligation to pay any unpaid fees that are due to the subcontractor and the consultant, which is great news for the consultant and subcontractor. Now, that's the liability position. What you often find when this scenario happens is that the employer does step into the contractor, but tries to negotiate a slightly different deal with subcontractors and consultants. Because very often what you find is employer will have paid the contractor, or may have paid the contractor what it's due in full. It's just that the contractor hasn't then paid the consultants and the subcontractors. The money's gone elsewhere. So, it then feels a little bit unfair to the employer to then have to start paying subcontractors and consultants. So sometimes a deal is done on that. Next slide, please. Yep, so we've covered that. Next slide, please. Yep. So, and yep, next slide. And the next slide. And the next slide. Okay, so on to the other employer protections. So if we can move on to the next slide, please, Jen. So the first one is retention. I think we can deal with this fairly quickly because I'm sure you understand what this is about. It's dealt with in NEC 3 as an option clause, so it's X16. Again, if it's not included when you're reviewing your contract prior to signing it, make sure that it's not included in your Z clauses, because typically clients, employers do want some retention. How it works very simply is that contract data part 1 states how much retention is deducted at every payment, generally 3 or 6%, but it's up for negotiation. Don't feel that you've got to accept a particular figure, but once you've signed the contract, you're stuck with whatever figure. At completion of the works, half of that retention is then paid, which is why, there's always a driver for contractors and subcontractors to get to completion. And then the balance, so the remaining 50% of the retention, is usually payable at the end of the defects period, which in my experience is when contractors, subcontractors quite often experience difficulty in getting that money paid, particularly subcontractors. And it's often a sort of relatively small amount of money, but makes real inroads into the profitability of a project if you can't recover it. one thing, so next slide, please, Jen. I just can't remember if I've... Yeah, so that's all been dealt with, except for the final bullet point deals with the possibility of a retention bond, which has been introduced in NEC 4. And they started to get quite popular probably pre-COVID. My perception is that they kind of seem to be going out of fashion again. But basically, we'll look at what a bond is later on. But it's basically insurance backed or bank backed, and you pay for it rather than having the retention deducted. The big controversy with regard to retention is that kind of a long time ago, before I was even involved in construction projects, the retention always used to be held by the client in a sort of escrow account, which means it's held in an account for the benefit of the party who it belongs to, so the contractor usually. And the good thing about that was that if the client stroke employer went into liquidation, that money was safe. It could be returned to the contractor. But for a long time now, that hasn't been the case. So if the party holding the retention goes into liquidation, then it's really unfortunate for the party whose money it is, because they're not going to recover it. They will just rank as an unsecured creditor, and be left to recover whatever they can on that basis. There was a move about 2017 to bring in a private members bill to kind of help this situation, but as far as I'm aware, it sort of it seemed to disappear in COVID, and I've not heard anything more about it since. So just be aware of that. It's always worth asking if it can be held in a separate account. I don't know, presumably you wouldn't be contracting with a party if you thought they were likely to go into liquidation. But, if you're concerned about the solvency of the business, or, that it's a special purpose vehicle and, it might sort of disappear, then, it's something you should definitely think about. Next slide, please. Okay, parent company guarantee, another form of security for the client. So it's dealt with in NEC 3 at option X4 if it's required. Now, I probably shouldn't need to say this, but you can only provide a parent company guarantee if you have a parent company. So it's not something that everyone can provide. What it is a form of guarantee. So it will typically say, it will come from the parent company, and it will say something like, paraphrasing, I, parent company, guarantee the work that my contractor company is going to do. If they make, if they don't do the work very well, I'll be responsible for putting it right. If they have any liability to you, client stroke employer, then I will guarantee that also. So that's the kind of thing that it's saying. Obviously, that's paraphrasing it. So it's quite wide ranging. Typically, it will be executed as a deed. So that means it has 12-year liability, which is probably what the construction contract will have as well. So, it's quite a long-term liability for parent company. And I know when I've dealt with parent companies, they like to kind of be aware of, what projects they're guaranteeing and what their kind of guarantee level is at any one point. As with all of these documents, parent company guarantee is a contract in its own right. So the key thing is to read it and understand what it means. It's the words that count. So, I've just explained roughly what you would expect in a parent company guarantee, but it's what it actually says that really matters. So I've told you what they would normally say, but for example, we negotiated one where the parent company was not prepared to give anything more than basically, I'm the parent company, I will guarantee the work, but only to the extent of repairing any defects. I won't be liable for anything else. And if you don't get me to repair the defects, then I won't be liable for anything. So, you know, there are different forms of it. And again, you obviously need to run it past your parent company. You know, are they willing to give this guarantee, because it is wide ranging. It's probably not a problem until the contracting company goes into liquidation or can't pay its debts. And at that point, that's when really the parent company guarantee comes into its own. So the next slide, please. Yeah, so that's just self-explanatory about NEC4. Lovely. So then we come on to the performance bond. Now, again, situation is evolving, and I would say probably 6, 7, 8 years ago, what you would find would be for certain value of projects. So, you know, definitely, you know, under 2 million, parent company guarantee performance bond not requested at all, not needed, not even discussed. Work where there was no design, where it was just workmanship, for a slightly higher value, ditto. No parent company guarantee, no performance bond. And then higher value works, or works where the design was an obligation on the contractor, it might be a requirement for one or the other, but not necessarily both. We're now seeing requirements for much lower value contracts, sometimes where there's no design, but you know, quite often requiring both if there is a parent company. So just be careful about that. The performance bond, of course, is going to be very relevant if you don't have a parent company, because this is what you will generally be providing, you know, if you've got to provide any security. So it's dealt with at NEC3 at option X13. Again, as I've said, if you're reviewing your contract before signing and it's deleted, don't assume you're not providing any security. Check the Z clauses, which might provide it in more detail. So in NEC 3X15, as with all of these others, the form of the bond is appended to the scope of the works information. The amount is stated in part 1 of the contract data. For a performance bond, the norm is 10% of the contract value. And yeah, what were we going to say there? Sorry. Yeah, the amount of the bond, you need to consider that when you're tendering, when you're bidding for the work. So, you know, just in case you're thinking, well, what on earth is a performance bond? It's a bit like an insurance policy. So the provider will generally be the contractor's business banker or an insurance company, and basically they are paid money, so they don't do this for free. They're paid money to provide the performance bonds. The performance bond is between the bond supplier, which would be the bank or the insurer, operating on behalf of the contractor. So they will provide it to the employer. So they are the parties who will sign up to it, and also the contractor will sign up to it to agree that the bond supplier provides it on their behalf. So, you know, as we've said, they will be paid for it in the same way as you pay for an insurance policy. They're quite pricey. And again, talking about how things change, my understanding is that sort of pre-COVID and into COVID, it was quite difficult to get bonds from bond suppliers. I think the position has eased a little, but you know, you guys may have a better idea than that. We also have, can we just have the next slide, please, Jen? Yeah. So I just want to talk about generally about bonds. So that principle applies to other types of bond. So, you know, we've already had a look at and just had a noted retention bonds. You might have a performance bond, unlikely in your types of contract, but if a design and build contractor was building, say, a waste to energy plant, they might have a performance bond to ensure that the facility performed properly at completion. And again, you know, as with the parent company guarantee, it is the wording of the bond and what it says that is important. You know, I can tell you what a typical bond would say, but you need to carefully review the wording. And one thing that you need to look out for, particularly with a performance bond, is anything that says that payment will be made on demand, because what that means is that if the client stroke employer makes a demand to the bond supplier, the insurer, or the bank, they've got to pay up. There's no need for them to prove their claim. So that would be really, really unusual in a performance bond. I would expect a performance bond to say that payment would be made once the claim had been established by the client through adjudication or court, and the contractor has failed to make payment. And at that point, so basically there are various hoops. So it is genuine security. So client has to prove the validity of their claim through adjudication, has to make a demand of the contractor. The contractor has to fail to pay, and then at that point they can make a claim on the bond. This isn't meant to be something where a client just decides partway through the project that they're not that happy with performance. They think they're going to be due some money at some point, so they make a claim on the bond. And that's different to some of the other bonds. So, for example, retention bond, that might be on demand because, of course, you know, it's a substitute to retention that, you know, would ordinarily be deductible on each interim payment. So really, you know, it's really important to check, you know, whether the payment is on demand or upon, you know, proof of claim, stroke adjudication award, etc. Next slide, please. Okay, so I'm probably not going to talk too much about delay damages because I'm sure you're aware of them. They're dealt with in NEC 3 and 4 at option X7. So they are liquidated damages. Be aware that if, for example, you say not applicable, the general rule is that you are saying liquidated damages are not applicable. It's not saying damages for delay are not applicable, so you would be paying general damages instead. If, for example, option X7 said yes, it applied and the damages were £0 or £0, then that basically means that if you're 3 weeks delayed and it's £0 per week, then you do the maths. 3 weeks times £0 equals £0. So, you know, you have got a liquidated damages clause. It is just at 0. So it's always going to be nil. So there is a distinction there. And I think apart from that, yeah, I just wanted to, you know, I just want you to be aware that, you know, that's another deduction that client can make. So this will be predominantly against the contractor because subcontractors don't tend to have liquidated damages. But again, you know, with a subcontractor, the contractor is most likely to deduct general damages from them. So again, you know, it's another way of retaining money that would otherwise be due to the contractor. And then at that point, contractor or in a subcontract, the subcontractor, if they can't negotiate a resolution that's satisfactory to them, would have to proceed to adjudication, prove that they're entitled to an extension of time, in order to recover those delay damages. Next slide, please, Joan. Okay, so we've touched upon this already, and we looked at it also last month. And so this is something that potentially benefits contractors and subcontractors, not the client. So X15 means that if the parties opt into it, it means the contractor's liability for design is limited to reasonable skill and care rather than fitness for purpose. If it's not opted into, then the contractor is automatically on a fitness for purpose. So, for example, professional indemnity insurance won't cover that fitness for purpose element. So it's not great news. So, it is a risk to the contractor in terms of the extent of their liability, should, the works prove to be defective at all. So the next slide, please. So limiting liability. So this totally benefits the contractor or the subcontractor. Well, yeah. So the clause is X18, so it's an optional clause. And I always say this when I talk about this. I did once see that X18 was included in the contract. So I was reviewing for, I think it was a subcontract. So I was reviewing for the subcontractor. So I'm thinking, great, they've got a limitation of liability clause. But then when I looked at the Z clauses, what it said was, this limitation of liability clause actually applies to limiting the liability of the contractor as against the subcontractor. So it wasn't limiting the liability. So, that's the importance of, reading the contract and checking the Z clauses carefully. So why I want to talk about this is that, it's quite a nice limitation of liability clause. It covers various angles. So it includes the time that the contractor is going to be liable. There's a provision to cap the total amount that the subcontractor will be liable for, to limit consequential losses, albeit that, that's don't start thinking, consequential losses include things like loss of profit. They don't. Consequential losses is a very, very limited scope of loss. Basically, direct losses are anything that you, when you enter into a contract, could foresee the other party incurring in terms of loss if you breach the contract. So, if you're going to build a facility, when you sign the contract, if you think about, well, if the foundations start to kind of crumble in year 3 after completion, what might happen? Well, expensive remedial works, building might have to be closed down, people using it might have to be decanted elsewhere, alternative accommodation provided, there might be loss of profit, because, the people using the building, might vacate and move elsewhere, all sorts of, and all of that would be direct loss relating to the defect. So, just be careful of that. Also, there's a nice cap on liability, that I've already pointed out, and typically that would be, the industry norm seems to be that, the cap on liability is the contract value, the contract price. But what we tend to see are lots of exclusions from that. So first point is a nice cap on liability for contractors, so that their maximum liability is the contract price. Lovely. But then it goes on to say, well, no, that excludes any monies that are covered by insurance, even if the insurers don't pay out on it. So that's one carve out. It includes anything to do with copyright. Excludes. It excludes anything to do with delay. So when you've got to the end of this list of exclusions, you wonder actually what your cap covers, because it ends up being very limited. So, they're quite tricky, these clauses. It's a good clause, but you need to pay attention to what it covers and what it doesn't cover. Next slide, please. So this is the last one. So clause 50.3, this is your program. Actually, I think that's a typo at the first bullet point. If the program isn't submitted within the timescales, then the employer can deduct 25% from anything due. It's submitting it that's the important point, not getting it accepted. So again, you know, just be careful of that. If your program isn't appended to the contract, you're going to have to submit it once the contract's signed. So make sure you get it in within the timescales. Otherwise, client is entitled to deduct that 25%, which won't be great for cash flow. You know, you would then obviously submit your program, and the next interim payment application, you'd be entitled to your 25% to be paid. But it's not a great start, and it's not going to impress your bosses. And I think if we can have the next slide, that's everything. Yeah. So I'm happy to deal with any questions if we have any.
No questions in the chat. Thank you very much, Sarah. And a big thank you from us all for another great webinar. If you do have any questions that you think about having reflected, then by all means, if you want to pop them over to myself in an email, then I can get the answers from Sarah and we can email those out. In terms of